Thank you, Denisio, for the great introduction. Yes, we will talk about staking mechanisms. Staking is an important part of the Cardano ecosystem, of course, because it's a proof-of-stake blockchain. But actually, staking is a term that is used quite widely in the crypto ecosystem. So first, some disambiguation. So it's actually important to distinguish what we talk about when we talk about staking. Unfortunately, in the crypto space, we have this tendency of using words with different meanings and kind of like recycling words. Let's start from like the false staking. There are a lot of like DeFi protocols that use the word staking in a honestly improper way. For instance, even Aave, you can stake their tokens, but it's actually lending because you put them in a pool, and there is actually a risk that eventually these tokens get lost in case basically the protocol needs to claim them back in order to basically offset for some losses. But they call it staking. Why? Because in the end, you lock the tokens into a smart contract, and when you lock a token into a smart contract, it's often referred to as staking. Then there are other forms of staking, like staking as a service, when you stake through basically a third party, like an exchange, and they call it staking as well. That's a bit more true, okay, but it's still not really staking. There's also liquid stakings, like you can do on Lido, basically, where you do staking, but then they give to you some kind of like other tokens that are wrappers of the token that you put on staking. Still, they call it staking. And then there is what we say is the true staking. So the staking that you actually use within proof-of-stake blockchain to validate transactions. Now, also, maybe before we pass to the next slide, let's try to understand where are the regulatory issues. For sure, there are regulatory issues with the false staking. When we are talking about lending and DeFi, there are a lot of, let's say, regulatory concerns about DeFi. There are regulatory concerns also about, let's say, other stakings, so staking as a service, liquid staking. While on the true staking, so the service that you perform for your blockchain to help the blockchain validate transactions, that's actually not very concerning from a regulatory perspective. Now, let's try also to understand why staking is concerning for financial regulators. I think that one kind of like exercise that we need to do in the crypto space is to try to put ourselves in the shoes of regulators and of the people that are really outside of our industry and that look at our industry from a third-party point of view and try to understand what we are doing and what's going on. Why staking is concerning for them? Because staking resembles a lot a financial yield, basically. It seems that you give like you lock your money somewhere and you get a yield. And for someone that has been trained all his life to look at debt securities, bonds, obligations, and so on, they say, I know what this is. I perfectly have seen it many other times, but actually, no. Actually, they don't get what it is. Because staking, yes, entails the distribution of rewards, and these rewards are often calculated as a percentage. And so, again, very similar to how a financial yield works. But the reason why you do that and how it works is completely different. Indeed, like whereas a yield rewards an investment, staking rewards the performance of a service that is necessary for the functioning of a blockchain network. Now, it's interesting to analyze bank deposits via staking deposits because in conversations with regulators, they did this analogy, and when they did it in front of me, I was like, but no, guys, like you are really not getting it. Because when you deposit your money in a bank, then the bank uses this money, they lend it to someone else, or they do investments, they do whatever they want, but basically they appropriate of your money, and they use it for other purposes, and they remunerate the fact that you are giving them your money. With staking, doesn't happen. With the true staking, I mean, what happens is that the stake tokens stay there. It's not that Cardano or any other chain, they take your token and they use it to something else. And in particular, they don't use it to generate a financial return for them that then they, let's say, remunerate you for. Now, basically, as we said before, the staking per se, so the direct staking, the one that every user can do, doesn't trigger many regulatory concerns. What it's more concerning from a regulatory point of view is the performance of staking as a service, which a lot of exchanges do, actually most exchanges do. And so how to understand when you are a kind of like staking as a service provider what's the situation for you? What are the criteria, the factors that influence basically the regulatory framework in which you move in? Well, for sure, the custody of the tokens. So do you actually take custody of these tokens? What is the unlocking time? Is it just the, let's say, technical time that takes to move the tokens out of the smart contract, or are you putting some time on top of that because actually you are taking control of those tokens and then you are releasing them to the users? Staking rewards, how these rewards are calculated? Are you really just giving the rewards generated by the network to the users, or are you keeping a part of it? Are you keeping all of them and giving to the user something else? And also, of course, the locking of the tokens, which is connected both to the custody and to the unlocking time. In particular, so now we go a bit more technical. What really matters is the power of disposal. The power of disposal is the power basically to move the assets, to dispose of the assets, to give them. And really the core difference in the regulatory framework applicable to a staking as a service provider is if they do have power of disposal or they do not. We can say that power of disposal aligns basically, or let's say, is the same thing as custody. I would say yes, quite the same thing, but there are some let's say, different nuances. So the point is, when the users surrender the power of disposal, so they give you the assets, and you, as a staking as a service provider, take control of the assets, then more heavy regulatory consequences are there for what you do. But when you allow the users to retain the power of disposal, so you are a non-custodial provider, then actually you are in a far better situation from a regulatory point of view. And now we will really analyze some different cases. One point that I can anticipate that relates specifically to Cardano is that, as you know how, let's say, stake pool operators work, actually you never surrender the power of disposal. You can continue to move your ADA even when they are on staking. So actually Cardano as a way of doing staking that from a regulatory point of view is very safe and also is very difficult for a regulator to claim that this is not the case. So let's analyze really the staking as a service, and in particular now we take some different regulatory perspectives also, because when we talk about regulation in the crypto space, it's very confusing sometimes to speak about regulation in general. The word is made out of different legal systems, different jurisdictions that have very different approaches to the crypto space. In particular, the US approach and the European approach are very different, if not opposite in certain cases. And I think analyzing the case of Kraken will really help us understand what's going on. So the point is that in February 2023, so earlier this year, quite recently, Kraken settled with the SEC. They paid a fine of $30 million, and they interrupted any staking as a service for US clients. So basically, I am a Kraken user, and I've been doing staking on Kraken for many years. I'm a European user, so it's fine for me to change anything. But if you are an American user, those functions are not more available for you. And why is that? Because it's really how the SEC sees this. And it's very interesting and probably not expected for you to understand why the SEC sees that. If you look at really like the claims that the SEC has against Kraken, they focus their argument against Kraken on the advertising, on the marketing that Kraken does. Because Kraken in their marketing communication says that basically you can get as much as like 21% returns and so on. Now, I don't know specifically what kind of communications they took. Probably they were bull market communications, but let's leave it at that. The point is that the SEC says that those communications generate in the user an expectation for profits. And then they linked these kind of expectations to the way in which Kraken does staking, which is really, let's say, important to analyze, because Kraken does not, or was not merely providing a technological service. They were not really just connecting your wallet and doing, let's say, enabling you to do staking, but actually they built their own pool. They were basically putting like 90% or 95% of the tokens in the pool on staking. They were keeping 5% of the token liquid so that it was more easy, more facilitated to move in and out the wallets, even for them. And even with regard to the staking rewards, they were not really giving you the staking rewards that were generated by the network. They were giving you some staking rewards calculated according to their own mechanism, and then they were retaining a part from themselves. So it is actually quite similar to a financial yield, this thing, because basically you were lending your tokens to Kraken. Kraken was doing whatever they wanted, and they were paying you a yield that was not really depending on how much they were getting from staking. Okay, it was depending because, of course, it needs to be a profitable business, and Kraken will give you basically a fraction of what they get, but it was not a technological service. They didn't build it like that. But it's still very interesting to notice that even within the SEC, and maybe you would not expect that, there was highly criticism about this. There is the commissioner of the SEC that really spoke out and said, we should not do that. We should not regulate crypto and target service providers just by enforcing regulatory actions against them, by fining them, and by preventing them to do things. We should work with crypto players, like in particular players like Kraken that are serious and actually would like to be compliant. And basically what they said is like the approach we are taking is completely detrimental to the industry, is detrimental to the US as a location for crypto business, which I think we all know because I think nobody of you would start a crypto business in the US. And therefore, I think it's a good starting point for a change in the US approach. We can now analyze the Swiss perspective. So we're based in Switzerland, so disclaimer. And Switzerland is one of the best jurisdictions in terms of crypto regulation because they have some good laws, yes, but honestly, it's even more the fact that the FINMA, which is the Swiss financial regulator, has a quite open approach, and also they really enhance and foster dialogue with crypto players. So it's really different from the approach of the SEC. It's not the approach of a policeman. Of a policeman is the approach of someone that really comes and speak with you and try to understand what you are doing and to establish the rules together with the industry. Now, they also noticed that there is a problem with what Kraken and other exchanges were doing, and they are also not okay with, let's say, that way of providing a staking service. And in the end, basically, if you do custody on a general address, so you pool together all the assets of your users, they don't have any, let's say, again, it's not a technological service. You are just basically borrowing assets from your users and paying them a yield that they require you to have a banking license. But in the other cases, no. They still want you to basically perform anti-money laundering thing. Or they maybe want you to have a fintech license, depending on basically if you make the tokens available at all times. So if a person can withdraw at all times. Of course, I mean, we have to take into consideration that per se staking entails a certain unlocking time. But this is a technical time. The point is that the technical time should not be derogated. You, as a service provider, should not put additional time that is, let's say, for your own purposes and nothing to do with the technological side. And then the difference is between the custody on the individual address. So each user has their own address, and also they can withdraw at all times. So then you are just a financial intermediary, which is honestly quite simple to become in Switzerland. You just need to perform KYC, basically anti-money laundering checks. Or if you custody on a general address, then basically you'll need a fintech license. Why so? Because there are different risks. So the FINMA thinks that if every user has an individual address, it's less risky. And here basically is the point, like, why do you need to be a financial intermediary in any case? because you basically help them in the investment or transfer of assets, and therefore you qualify as a financial intermediary. And again, the principle is the power of disposal. Now we come really to the Cardano ecosystem, and let's analyze why in the Cardano ecosystem staking is not problematic. What we were saying before, it does not transfer of the power of disposal. The power of disposal stays with the token owners. So there is no, like the main argument for regulators in trying to enforce regulators against staking as a service provider falls. So on Cardano, even more, you stake your wallet more than your token. So now, I'm not a very technical person, but I did analyze this thing with some technical person. They explained it very well. I'm not sure I can explain it as well to you, but I'm quite sure that this is the case. And really the point is that you lock your wallet within a stake pool operator and not really your token, and this is why you can continue to transfer your tokens. And what happens when you transfer your tokens to another wallet is that simply they kind of like went away from your stake pool operator, and you have to redelegate them to either the same or another stake pool operator. And of course, then there is this one that is a main point and consequence of these two, the fact that you can continue to transfer your ADA. And of course, again, as a consequence of the above, the fact that the stake pool operator never acquire custody of the user token. But based on what we said earlier, even if you are a stake pool operator and you want to build a platform that is more sophisticated than that, you want to be a staking as a service provider, and you want to take custody of the tokens, if you do that in Switzerland, basically you just need to be regulated as a financial intermediary. And the real point is you need to provide a technological service. What you should not do is what Kraken was doing. So you should not borrow the tokens of your users and basically do whatever you want with them, but you should just enable them to do staking, real staking, through your platform. So that's basically the point. That's it, and I would really like to open the room for questions because the topic I think is quite interesting and also can affect many of you in terms of like the services you offer. So.
The way you put real staking, it really sounds like that it fits delegated staking mechanism on Cardano. Later on, we have stated that actually the staking mechanism we have in place on this platform is actually fulfilling these stakes, because on your slide you said something like direct staking, but here is more like delegated mechanism.
It is true. Like it's often difficult to align the kind of like legal terminology with the technical one. But I mean, the point of true staking is not really to do direct staking. The point of like what is the true staking is that you actually participate in transaction validation within a proof of stake blockchain. This is the point, because the staking, so-called staking, that you do on a platform like Aave, and like I don't have anything against Aave, I also use Aave, so it's totally fine, but they say staking when there is no proof of stake, basically blockchain, like there is nothing that has to do with validating transaction in a proof of stake network. It's just lending. You lend them tokens.
Like borrowing and lending, right?
Yeah. Maybe I'll tell my interns. No, could, yeah, okay, could be, yeah.
Yeah, I also have a question later. Regarding the revenue, because you mentioned that also the plays very important role is party is generating revenue from himself, right? The Cardano platform is actually possible for stake pool operators to set a fee. So they are generating revenue for themselves, and it can be also quite high for different purposes. So that's
Thank you for the question. Actually, that's a very important point. It's fine. It's fine to charge a fee. The important is actually to distinguish, let's say, between a fee and, so this one is maybe a complex one. So again, you can charge a fee because you provide a service, and the fee can even be calculated on the staking rewards, but the fee needs to be transparent first. So you need actually to tell your users what are you charging in terms of fee, which was not the case on Kraken. Because on Kraken, the point is that they were telling you, I will give you this return. And usually they give you a fork, actually. They don't give you a percentage. They tell you like it's between 3 and 6 or 4 and 12, whatever. And then it's not transparent. You don't know how it is calculated. And it's not really depending on the rewards that are generated by the network. It's depending on how Kraken set their own fee calculation mechanism. And again, it resembles a lot a financial yield because I'm giving you an instrument that has a variable yield depending on some characteristics that I decide. And this is very similar to basically how a bond works. Please.
How does that relate to the MiCA guidelines?
That's a good one. So actually, so MiCA is a good regulation, in my opinion. The problem of MiCA is that it is an older regulation because so 2 things. The legislative process of the European Union is very, very complex. It entails the fact that the European Commission proposes a regulation, then it goes through the Parliament, then the European Council, that a lot of states have to agree on it, and so it's very long. MiCA has been proposed almost 3 years ago, and so has been drafted 3 years ago. And therefore, MiCA does not cover DeFi. They don't cover DAOs. They cover utility tokens briefly. There are 14 articles dedicated to utility tokens. That's it. And then they cover crypto asset service providers, CASPs, which have a quite broad definition. So we can say that a staking as a service provider that takes custody of the tokens does qualify as a CASP. So that regime is applicable to them. But basically that's it. There is not specific regulation that concerns like staking, or I think staking is not even like mentioned in the regulation once.
So staking on Cardano is actually a juridical void at this point.
That's a good point. Yes, staking on Cardano, so the operations of a stake pool operator do not fall in the regulatory scope of MiCA. Yep.
Maybe I have a question. I understand if you become a crypto business involved in lending and staking, that there are like better and worse jurisdictions to go to. But even if I choose to incorporate in a more reasonable jurisdiction, such as Switzerland, how do I then target customers globally? Because still, the jurisdiction of every single country where my customers are coming.
That's a bit of a problem. So in financial regulation, usually you have to apply the law of your customer. So when you're targeting a customer in a specific jurisdiction, you should be compliant with their law, apart from the cases of reverse solicitation. So in the case it's a user, let's say that you have a platform in Switzerland, and then a user from France comes to your platform and they want to register and they want to do things on your platform. It is actually allowed and you can let him in, but you cannot do advertising in France. So if you really actively go in France and solicit users to come on your platform, then you need to be regulated also in France. This is how it works. With the US, it's the only country in which this principle is actually a bit more complicated and risky, because US authorities, they claim that if you involve a US person, then their law applies. It's a bit like bullying, but it is what it is. And given that they are very severe, I usually advise my clients that either they get regulated in the US or simply they geo-block basically users from the United States to access their platforms. But in terms of like how you operate with that, well, at the moment, for instance, MiCA in Europe is not applicable yet. The regulation is valid and in force, but will become applicable part this like next summer and part in December 2024. Basically, till then, we are still in a gray area in which you can operate. And also you have to think that, okay, the law should be very, let's say, clear, but actually not really, in the sense that still the market is full of like unregulated parties and players. And if you get regulated in a jurisdiction, so you are licensed and so on, it's not really likely that then other regulators will come to you and chase you because you are not regulated also in their jurisdiction. Also because, honestly, these kind of regulations, in particular financial regulations were not drafted thinking of, let's say, our world. Crypto is transnational by its own nature. Like you can have users from all over the world. And those regulations, in particular the offering of financial instruments, were drafted in a world in which this thing is done locally by a bank agency in your hometown. And therefore, there are some clashes, and even the regulator understands that there are those clashes. So I think the important thing is that if you do an activity that is regulated, pick a jurisdiction in which you can be regulated, get the licenses there, start operating there, and then you can start dialogue with other regulators in other jurisdictions, like in particular if they come to you, or even better, if you come to them in advance. Yeah.
With the uncertainty in the United States, how likely do you think the risk is that in the future somehow it might happen that legal operators would have to geo-block kind of American litigators, which is not possible right now, but there has been a discussion in Cardano about religion staking.
Well, the problem is, I don't know if you have been following, guys, the case against Coinbase or actually other recent cases of the SEC. The problem there is that the SEC thinks that ADA is a security. So we start from a very complicated ground. So, well, the point still is, in my opinion, that because of the characteristics of how stake pool operator works, it's very difficult even for the SEC to claim that this service is anything different from a technological service. You don't take control of the assets. You really just provide a technological service to them. So there is no financial service involved in that. The only maybe case could be that if you do some very aggressive advertising to convince users to delegate to your pool, saying that your pool has some like special features that will make them generate more rewards, which is probably false, then you could fall into that. So it's actually, I think that my key point on that is like, be careful with what you say. What we do also with our clients is that we actively work with their marketing team to review their communications. Not everything they say, but we give them guidelines, and then with like more important things, we really review the communications. Yeah.
Can you say what these words are?
Well, some clients in the past, they asked me to give them a list of like forbidden words. I think to some extent we did that, but I mean you can get to it like yield, ROI, earn, gain. Like these sort of things. Reward is better, is already better. But yeah, I think with some common sense you can actually figure that. Yeah. The important thing is, are you generating in a person an expectation of profit or not?
We have time for like 2 questions.
I was wondering if you had some comments on the practice of initial stake pool offering, which is quite popular in Cardano.
Yeah. So yes, I am familiar with the way in which these offerings are made. I think that more than the modalities of the offering, it's important what you're offering. So how does the token that you're offering qualify? Is the token a utility token? Be qualified as a security token? And based on that, actually, is the most important part. The modalities of are not so important. So basically, if you are a service provider that allows this kind of offering, make sure that the project that is launching the token gives you a legal opinion that confirms the token is not a financial instrument or a security.
We have questions for one. Time for one more question.
Would you be able to answer questions regarding catalyst funds?
Yeah, sure. Go ahead.
It's regarding the source of funds.
Okay. Now, I mean, it's. I understand it is difficult. It is a grant. It depends on what kind of organization are you, basically. If you are a company, if you are an association or a foundation, but if you are a company, I would say is a revenue, and you should account it as a revenue. If you are not, then if you are a foundation or an association, then it could be tax-free because it's a kind of gift.
All right. Nicola.
Thank you.